Good afternoon, everyone. Thanks for joining us for today's webinar, Primary Considerations for Primary Care Leases, the Key Terms and Pitfalls Explained. My name is Myles Evans. I'm an associate here at Hempsons. Presenting with me today is my colleague Harry Armstrong, who's a solicitor. We're both in Hempsons' primary care real estate team. Today we'll be discussing the main provisions you would expect and hope, I suppose, to see in a GP lease, as well as some common risks and pitfalls that are associated with GP leases. Now, the subject of commercial leases can be complicated in itself, but throw into it an NHS context with how the funding works, the need to involve the ICBs, district valuers, different parties at different stages. They need to understand how the rent reimbursement process works, how the governing legislation works, that's the premises cost directions. There's a great deal there to think about. So I hope by the end of this webinar, you'll have at least an idea of the most, some of the most important terms of a GP lease. Now, by no means does that mean we have time to go through every important clause or provision. It's not an exhaustive list as such, but as I say, hopefully it will give you an insight into some of the main issues to consider. So for today's topics, we'll start with explaining in basic terms what a commercial lease is. We'll then talk about the importance and practicalities of thinking about who the tenant is for the purposes of the lease, how the rent reimbursement process works, what the nuances are there, depending on the type of lease you may have. We'll cover rent reviews, and we'll also cover break options, the ones you would expect to see in a GP lease at least, and we'll finish off with assignments of leases and alienation generally, and some of the risks there. I'll just flag before we get into it, so when it comes to lease negotiations, it's advisable to seek expert advice, both from a solicitor and a surveyor or valuer, as early as possible to make sure that your lease is well negotiated, not just to include the GP specific terms that we're discussing here, but to make sure the deal sort of overall is a fair and balanced one. But certainly get advice from a specialist in the primary care sector, because as some of you will know, and as will become apparent, I think, this is a niche area within the context of commercial leases, not least because of the involvement of third parties. Which we'll come on to in more detail shortly. So as I say, I hope you find this useful, and I'll just reiterate what Jess said there at the beginning, that we'll have some time at the end for questions, and you can either add your questions as we go, or you can wait till the end, and we'll pick them up there, and hopefully do as much as we can in the time we have. So with that, I'll hand over to Harry to kick us off.
Great, thank you, Myles, and good afternoon, everybody. Thanks for joining us again. So yeah, what is a commercial lease? To break it down, it's a legally binding contract between two parties. In this context, it's a landlord and a tenant, and it grants the tenant the right to exclusively occupy a property for business purposes. This will be for an agreed period. We refer to it as the term or the contractual term. This will be in return for rent, and often a service charge too, and of course other obligations. The obligations come in the form of covenants or promises, as you may hear me talking about that later on in the discussion. The type of lease we'll be discussing today are what known as rack rent leases. So it's principally a lease granted typically for a term of say 5, 10 or 15 years, and where the annual rent is paid. So that's the basic set out of them. This is distinct from other types of leases, which we're not discussing today. For example, a capital lease. This is a lease granted for a longer period of time. This could be from, say, 125 years or even 999 years. There's usually no annual rent payable, and instead the lease It's granted at a one-off premium, and you may see terms or payments referred to as at a peppercorn if demanded. For a bit more context, this is so that there's consideration for the contract, as this is needed for it to be legally binding. So yeah, just to say that we're not covering that off, but it's worth knowing that there are those other types of leases, and they may need to be known about for what we're talking about later on. And just to slightly digress again, you may occupy a space under a license to occupy, or even a rental authority letter or tenancy at will. These are very much more temporary or limited grants of rights over the property, and certainly in the case of a license to occupy, you'll only have non-exclusive use with this type of arrangement. So distinction should also be made for these types of property arrangements. Now we're going to be discussing on the next slides what we'd expect to see in a GP lease and a breakdown of some common clauses. So this actually implies that there is in fact a written lease, which isn't always the case. You can still have a lease without it being in writing. This can be for all kinds of reasons, but it's worth knowing that and flagging that at this stage. So I'll hand back to Myles, who's going to pick up the next slide on the entity of a tenant.
Brilliant, thanks, Harry. Yeah, so as Harry's saying, we're going to be focusing on the rack rent style leases as opposed to the longer capital leases. And one of the main questions that comes up early on is, well, who is the tenant going to be? What is the tenant entity that's actually entering into that lease? Because in a GP context, the practice as such doesn't constitute a legal entity. It's a partnership, so it doesn't have a capacity to enter into binding legal obligations. So who is it? Well, it's the individual partners who have the ability to actually enter into contracts and therefore enter into a lease. Now, because of a quirk with the land registry, which I don't need to go into now, up to a maximum of 4 partners of the partnership can be named on the leasehold title at any given time. So if there are more than 4 partners, then a question immediately arises, a decision has to be made, which partners are going to go onto the lease. Now, generally speaking, it's fair to assume the lease is going to be partnership property. It's obviously being used for the benefit of the business, as it were. So it almost certainly will be partnership property. And the named partners on that lease will hold it on trust for all themselves and the other partners in the practice. And then what will happen is, although the lease itself is limited to say 3 or 4 names, the partnership deed held separately will document the fact that the lease liabilities are shared between the partners, between all partners. So sort of fundamental point there is that the sharing of that lease liability is contained in a separate document, i.e. your partnership deed. So from the landlord's perspective, and so far as the landlord is concerned, the named partners on the lease are the contracted parties, and they have what's called joint and several liability, meaning that the landlord could pursue any one or more of the named partners for 100% of costs or damages arising from a breach of the lease, or they could choose to pursue one partner for 50% and another for 25%. The point is the landlord has a good deal of flexibility in terms of, in a dispute scenario, choosing which of the partners to go after effectively. And you can imagine if the partners have very different financial circumstances, then the landlord may well make a commercial decision about who it is that's worth pursuing. As I say, he could decide to pursue all 4, or let's say there's 4 named on the lease, he could pursue all 4 equally, or he could pick and choose which of the partners he wants to pursue. So that's why it's imperative to have that partnership deed kept up to date, so to make sure that the lease liabilities are properly shared as intended between the partners as a whole, because it's the named partners who are sort of in the firing line, as it were, so far as the landlord is concerned. That is I'll leave that there at the risk of going down another tangent and move on to rent reimbursement. Sorry, I'll move on. Rent reimbursement is the next topic. So now most tenants, as you'll appreciate, pay a rent out of their own pocket. It's a business expense, as it were. But one of the more distinctive aspects of GP leases, which I'm sure many of you are aware of or feel familiar with, is rent reimbursement. What is it? Well, it's an payment from the ICB to a GP contractor to cover qualifying premises costs. Now, that phrase includes notional rent, which relates to owner-occupiers, as in the scenario where the GPs own the building from which they provide services themselves. And on the other hand, it also covers the leasehold reimbursement cost that we're focusing on here today. The rules and the mechanism for those payments are set out in the NHS premises cost directions, and rent reimbursement is the mechanism by which the GP practices who occupy leasehold premises can recover the rent and perhaps other costs, which we'll come on to, from the ICB. So just in terms of a brief summary of what is and isn't funded. So what is funded is what's called the current market rent, often referred to as CMR. And I'm going to come on to that in a bit more detail because I think it's relevant and helpful. But on top of the CMR, the current market rent, the other reimbursable costs are business rates, water and sewage charges, clinical waste. And in terms of what's not funded, there you're looking at it's the internal repairs and decoration, utilities, what are often termed soft FM services. So your security, cleaning, shared receptions are the examples I've got on the slide, and service charges generally. So eligibility, who does it apply to? Well, rent reimbursement applies to GPs holding a core NHS contract, whether that's GMS, PMS, or APMS if negotiated. And the premises must be an approved premises under the directions, meaning that the premises are used wholly or mainly for NHS primary medical services and are suitable for that use and have been approved by NHS England, the ICB, for that purpose. An important point, which is often not known, is that the rent reimbursement is only available for the space that is reasonably required for the NHS services. So not for any private work or parts of the building that might be surplus to requirements and not in use. Or, for example, if you've let part of the premises to a pharmacy or some other healthcare provider, the point is you can't effectively receive a double income for that space. But what you can do and what you're allowed to do is to, if you are sharing the space, is perhaps arrange for a contribution to be made by that third party occupying towards your non-reimbursable costs. That should be completely fine, provided that you're not charging that third party for a rent itself. It's only an issue if you have an income from them, a rental income from them, again with that double income principle. So if you do have any arrangements like that within your practice, it's worth thinking about it because, well, on the one hand, it's worth checking whether is there any potential additional income we can get here from this arrangement? Can we require the occupier to at least contribute to the non-reimbursable costs, but also to consider it from the perspective of making sure you're not falling foul of the double income principle. So moving on to how is the level of rent reimbursement determined? And this is an extremely important point because the rent that's reimbursed is not simply what the lease says the rent is. As I mentioned before, it's CMR, current market rent. And essentially that is the market rent for your premises including some funding to reflect additional costs relating to external maintenance and buildings insurance, perhaps, to the extent that that's relevant to your lease. And I'll explain that in a bit more detail shortly. So just in terms of that principle, to use a sort of crude example, if you were to provisionally agree a lease or terms for a lease with a landlord with an annual rent of, say, £30,000 per year, it's not that the ICB does not simply reimburse that figure. Instead, the ICB will be advised by the district valuers what they consider to be the current market rent, CMR. And let's say the DV says, well, actually, we think the annual rent here is, let's say the DV say the CMR here is £28,000, then that is the amount that would be reimbursed. So you can see in that example, there would be a potential £2,000 shortfall. And then just generally speaking, from a negotiation standpoint, this can create tension between a landlord and a tenant, because the practice obviously wants the lease rent to align with the DV's valuation of CMR, while the landlord wants to push the rent to its highest point possible, generally speaking. In that scenario, it can become a question of bargaining positions in terms of which way it goes. So this is sort of the fundamental point, is that from a GP's perspective, is to make sure to get that lease, the actual lease itself, approved by the ICB, having been advised by the district valuer, before you are committed to that lease. It's only with that approval that you can be sure that you will get the reimbursement. So I mentioned earlier that the type of lease is also relevant. So how does the type of lease impact rent reimbursement and CMR? Well, I need to first distinguish between broadly two types of lease. Why? Because let's say, in a sort of silly example, if two leases were granted in the same building to different tenants, those leases could technically attract very different reimbursement levels depending on the type of lease they are. Now, I say that's a silly example because in a commercial context, a landlord is not often going to be wanting to grant different types of leases to tenants within the same building. So it's a very rare case. But just to illustrate the point, it really matters what type of lease we're talking about when it comes to CMR. So the first type of lease is an FRI lease. It's a full repairing and insuring lease, meaning that the tenant, the GPs, are responsible for all the repairs, maintenance, and insurance costs for the entire property, both internal and external, and that would include structural as well. But perhaps just to complicate things a little further, there are two types of FRI lease, really. It could be an FRI lease of whole, where the costs of repair and maintenance sit completely with the GP tenant, and the GP tenants themselves have to be carrying out those works or procuring that those works are carried out. The second FRI lease would be a FRI lease of part, where the tenant still has responsibility for repair and maintenance of the exterior of the building, of the structure, etc. But the obligation to carry out those works sits with the landlord, and the landlord can then recover those costs, or some of those costs, via the service charge. So the first type of lease, FRI, two types. The second type of lease is the IRI lease, which is internal repairing and insuring. And all that means is that tenants' responsibilities, so far as repairs and maintenance are concerned, are limited to just the internal parts of the property, just effectively the four walls, anything within the four walls, if you like. In that type of lease, the landlord will take sole responsibility for external structural maintenance, repairs, upkeep of common parts, etc., and won't have any mechanism to recover those costs from the tenant. So hopefully that is clear enough on the types of lease we're broadly talking about. So in an FRI context, the CMR, the current market rent, will take account of the tenant's liabilities in respect of repair and insurance. And I've discussed earlier that this should be reflected in the CMR by stating that the amount of the CMR which the GPs can hold back to cover that liability. So point is, you will have the CMR is effectively a single figure, but a portion of that CMR should be being held back by the GPs to reflect the fact that they have these liabilities or responsibilities under the lease. And my understanding from speaking with surveyors and valuers in this area is that that portion is generally in the region of 5 to 7.5% of the annual rent payable to the landlord. But obviously that can vary depending on the type of property and the extent of the tenant's obligations. So just a quick side note here, because I think Harry's going to touch briefly on repairs and dilapidations liabilities at the end. But just with this 5 to 7.5% portion in mind, being the portion that's retained by the practice, that should be retained for that purpose and built up over the life of the lease, such that by the end of the lease term, there should be a significant fund there that will hopefully be sufficient to cover any potential repair and dilapidations liability when the lease comes to an end. Problems are created when that's not done. That portion of the fund is not retained, and then at the end of the lease, the landlord serves a notice of dilapidations and requires the property to be reinstated to the state of repair it was in at the beginning of the lease, and that money is not there, has not been set aside. So, and you can imagine that then that can lead to issues. So just to make the distinction, on the other hand, with the IRI, internal repairing insuring lease, the CMR the current market rent should, in an ideal world, match the amount of the rent payable to the landlord under the lease, because again, the point is the tenant does not have, in that case, any obligations in respect of external repairs, maintenance. And then, so generally speaking, the fact that the lease is more favourable to a tenant in that respect is generally reflected in a higher annual rent payable to the landlord. But as I say, in terms of the CMR and the rent, those you would hope, be the same. And that's not to say that in the context of an internal repairing lease, there's no repair or potential delapse liabilities at all. It's just that it's limited to the internal parts of the premises, so it's unlikely, hopefully, to be a significant cost. So hopefully that's a clear explanation of the fundamental point that the DV and the ICB have to have regard to the actual terms of the lease itself, and that the CMR, the current market rent, is adjusted to take account of what type of lease it is. As I say, take account of any responsibilities of the tenant in respect of external repairs, maintenance, insurance of the building. Again, the important point throughout this presentation really is to get the lease approved first by the ICB, who, as I say, are advised by the district valuer. Once that's approved, it essentially, the confirmation is that the DV views that lease as value for money from the system's point of view, the NHS point of view. And that just ensures that the rent will be reimbursed at the appropriate level, so you avoid the risk of having a shortfall between the rent payable to your landlord and the rent reimbursed to you by the ICB. So I hope that's clear enough. Just to summarize some key takeaways there. Again, engage the ICB early when negotiating the lease, so that you can start discussing the rent level and reimbursement. Be clear on the repairing responsibilities, again, because that the extent of a tenant's repairing obligations can have an impact, a direct financial impact. Remember that the reimbursement is tied to the premises use for NHS services. And I'd also just mention that it's an ongoing, rent reimbursement itself is sort of an ongoing process. So throughout the life of the lease, if there are rent reviews, you'll have to go through the same or similar process again. And likewise, on a lease renewal, you'll have to go through the same process again. But I'll leave that because I know Harry's going to come on to rent reviews next.
Okay, so rent review. So as Myles was saying, might be some negotiations at the start of a lease to decide on the rent, but the landlord may reserve their position if they want to increase or just look at the rent during the lifetime of the lease. So after you've completed the lease, and this may typically happen on the third anniversary or the fifth anniversary, depending on the length of the term. But yeah, just to come back slightly, a rent review, put simply, is an opportunity for landlord and tenant to engage with each other to agree a new level of rent. Typically, it will be an increase, but as we found with the premises cost directions, it can be an upwards or a downwards review, depending on how the lease is drafted. So the lease will be drafted in a certain way. It will contain provisions which dictate how and when the review is meant to be carried out, i.e. who is responsible for triggering review and how are the decisions made. Decisions will be supported with the involvement of a surveyor. They can review the rental provision to the lease, and then they'll get to carry out the valuation exercise. Now, it's important to highlight a two-stage process, which has been put forward by the Premises Cost Directions 2024, and it would be important to include both of these within the draft lease. So stage one is negotiations between the landlord and tenant only. The ICB will not be involved at this juncture, and the practical considerations need to be taken into consideration between these two parties to determine what rent is suitable. Now, after that has been carried out, stage two, the tenant themselves speaks with the ICB and the DV can get involved and provide opinion. This needs to be drafted into the lease to avoid the situations where, as Myles mentioned earlier, you'll be left with a shortfall if there is a difference between the current market rent and the rent put forward by the landlord. But of course, we can include this drafting within the lease to avoid this eventuality. You may still see the older premises cost directions from 2013 being used, and that is getting the ICB DV involved from the off and just forwarding on any kind of rent review memorandum or notification from the landlord that the rent needs to be increased or needs to be reviewed. So yeah, you typically might still see that happening, but the two-stage process should be followed, and that will be the process going forward. So yeah, many of you may have had to wait for a DV value for money report before entering into a lease agreement before or agreeing terms for a renewal lease, and it's a very similar letter again, just to say that they've considered the rent review and then the different context to the lease. So yeah, we just move on to the next slide, please. Okay, so on top of the lease being drafted to include a referral to the DV at the right time with the rent review, there'll also be other commercial rent review mechanisms. So yeah, if there's a provision within the lease for the rent review to be passed on to the ICB, once this has happened, there may also be an agreed process within the lease. This might be in the form of an open market value review or a fixed increase, or it might be an index-linked increase, such as a retail price index or consumer price index. These can be commonly found in an under lease plus agreement or an ULPA, which few people attending today might occupy a premises under. This is with community health partnerships or NHS Property Services Limited. Now, in the example of an ULPA, understand that tenants will still get their rent reimbursed despite it not always being covered in the lease. But with an OPE, before you complete, you'd usually have approval to proceed from the DV for the life of the lease, as if the rent's being increased by RPI each year or at a certain date, they would have taken that into consideration and approved the whole thing to make sure you properly consider that up front. Now, when you come to review of rent, there may be a clause which says that time is of the essence or time is not of the essence. Now, the latter is usually the way forward with a GP lease as a standard position, as the time is not of the essence, which gives the landlord as much time as they need to review the rent. So even if that review date, which I mentioned on the third anniversary, is passed by however long, it doesn't really matter. The landlord will still get an opportunity to trigger the rent review. Now, I have seen certain cases where time is to be of the essence. So a DV or the lease itself may include wording which says that both parties need to use reasonable endeavours to agree on the new rent within a certain time period. So this could be 3 years, for example, and they may also include wording which says that both parties should have the ability to trigger a rent review, just so then if one party is aware that the rent's needing to be reviewed at a certain point, they can't just sit on it, and it basically just gets people to engage with the rent review. So yeah, as I said, this will be drafted in from the start of a lease usually, unless it's varied. Sometimes you can have a rent review which coincides with a variation of the lease, and within the variation of the lease, they may then change how the rent review is structured in itself. So that needs to be carefully considered too. So yeah, it's important that you don't sit on certain rent reviews. I had a recent GP client that was looking to take a lease from a trust. The trust had, I think, they had the second floor of a health centre and they had the first floor. They wanted to take on more space, and the trust had a 3-year backdated rent review, which hadn't gone through yet. So that kind of slowed things down with the GP client wanting to take the extra space. But this was eventually pushed through. But yeah, it's just important to make sure that if you're planning on dealing with the lease, that you've dealt with any rent reviews or outstanding matters under the lease. But yeah, I think I've covered everything on that point to do with rent review. So we'll just pass back to Myles. He's going to talk about break options.
Great, thanks, Harry. Yeah, just to reiterate, the sort of fundamental point with rent reviews, as Harry was saying, is this two-stage process. It's very much expected now under the 2024 directions that came out last year that the initial stage, in terms of negotiating that initial rent review figure, needs to occur between the landlord and the tenant, landlord and GPs, and only in the second stage will the ICB and the district valuers be involved. And the point from a legal perspective is to make sure that in your leases that there is this clear mechanism to ensure that the reviewed rent can never exceed that which is reimbursed by the ICB. And landlords are, usually completely happy to include that link. After all, they are effectively letting to a blue chip a blue chip tenant with effectively state backing for their rent. So they are a secure tenant, which is why the landlords tend to sort of not stand in the way of those types of provisions. So just moving on then to break options. What do we mean by a break option? It's a contractual right that allows either the landlord, the tenant, or both to end the lease early, so before the contractual expiry date. It's often on a specified date. So, for example, if we're talking about a 10-year lease, say, you might see a break option that can be exercised at year 5. Typically, break options are or those that are in favour of a tenant are subject to certain conditions. For example, the payment of rent must be up to date on the break date. The tenant can no longer be in occupation of the premises, and there must be no other third parties occupying under some kind of license or other sharing arrangement. So that's sort of break options. Generally, that's what they are. But when it comes to the GP specific break option that we would want to see, what do we mean by that? We mean a contractual right in favour of the GPs as tenant to terminate the lease early in the event that the GP contract, i.e. the core contract, again, whether that's GMS, PMS, APMS, is terminated or not renewed. So fundamentally, the point is that it's creating a link between the lease and the GP contract. That's often referred to as an Armageddon clause. Some of you might be familiar with that term. So why is that link so important? A practice's entitlement to rent reimbursement, as I was saying before, from the ICB, is contingent on that practice holding the core contract. So if you don't have the break clause that's linked to the loss of that contract, the risk is that the core contract could be terminated, thereby ending your entitlement to rent reimbursement. But the GPs, you as a GP, would be unable to bring your lease to an end, and therefore you remain on the hook, as it were, for all the lease liabilities for the remainder of that term. And as I've said before, the GPs, the named GPs, would be personally liable for those rents and other monies due under the lease without any means of getting those reimbursed. So that's a fundamental risk, and it's one of the key provisions we would expect to see in a GP lease. I would just add a couple of brief points around the drafting and maybe some detail. Sometimes these clauses are heavily negotiated, but sometimes you see the wording that can require GPs to, before exercising the break option, to try and find alternative funding or to try and find a third party entity that could take on the lease liabilities from them. But in our view, that wording should really be resisted. It just creates a good deal of uncertainty, because you can imagine that it can be very difficult to be sure that you've used sufficient effort, as it were, to try and find an alternative funder or to try and find a third party to take on your lease liabilities. And in a landlord and tenant context, a landlord had an expectation, or at least a hope, that they would be receiving a certain level of rent for a certain period of time. If that is now coming to an end somewhat unexpectedly because of the loss of the GP contract, then you can imagine a landlord is incentivized to find any and all arguments to suggest that the break option is invalid. So really the point is to try and keep these break options that are, especially those that are linked to the GP contract, to keep them as simple, straightforward as possible, so that you can be as sure as you possibly can that you can meet all of the conditions of that break without exposing yourself to risk of arguments from a landlord seeking to keep you on the hook for a few more years. That's all I have on the break. If you want to pick up on the alienation, Harry.
Yeah, of course. So alienation is also referred to as dealing with the lease. Suppose it's an alternative to breaking the lease, which ends the term, and each party kind of goes separate ways. Not very strictly speaking, but the first point would be an assignment as a way to offload the lease. This would be to another person or organisation, and following completion of the assignment, the person who's taken on the lease, the incoming tenant, will take on all of the obligations and liabilities within this lease. So of course, there's prior considerations to take before any assignment is considered. Now, if you're the one trying to offload your lease, it's best to keep your legal title and partnership in order. You should only know who is named on your leasehold title register if the lease is registered. So this is an important admin step to take just before you take an assignment on, and it will avoid quite a bit of confusion or anything unexpected later down the line. So when I say your lease is registered, if it's for 7 years or more, then it's compulsory for it to be registered at the land registry, depending on when it was entered into. Usually, if it was after 2003, which is probably more common with most leases, then this would be need to be registered at the land registry. I can't remember quite if Myles mentioned earlier on, but there should be 4 partners maximum named on the title register. So yeah, just check that lines up with the lease as you know takes on the liability of that lease. Of course, a distinction should be made from an underletting or subletting. It's different to an assignment. With an underletting, this is where the outgoing tenant is not absolved entirely from all their obligations under their lease, which we refer to as the superior or head lease, and they will have a contractual relationship with the landlord, which we refer to in this situation as a superior landlord. Now, with an assignment, you would expect the assignment of a whole rather than a part. This is just due to complications of apportioning rent and covenants, like promises, etc. An assignment will usually be affected by a license to assign, which sets out the outgoing and incoming tenant, references the lease which it relates to, and essentially documents the changeover of the lease, and mainly the consent of the landlord to this assignment taking place. From time to time, there may be changes to the GP practice, which will require the lease to be assigned, such as in the event of a retirement of a GP or a new appointment, for example. As I mentioned before about the partnership deed, this will contain obligations and timings around assignment. So you'll be able to rely on this to require certain partners to assign a lease or to document the process to be followed when a new appointment needs to be recorded in terms of the property arrangements. Now, in a normal commercial lease, you will almost certainly need consent from the landlord, and they will likely request an authorised guarantee agreement or another type of personal guarantee. Whereas, ideally, if we're drafting a GP lease, we don't want these restrictions, as an outgoing tenant with an ARGA will be liable for a lease that they are trying to offload. It's just to touch back on an ARGA again, an authorised guarantee agreement. This is where the outgoing tenant is effectively asked to keep an eye on the incoming tenant and be completely liable if the incoming tenant can't keep to their promises or make the payments under the lease. So with the chopping and changing that you might find for GP practice, this isn't very practical. So we'd look to avoid this arrangement. And as we mentioned about landlords being amenable to certain changes with rent reviews, with it being a blue chip client, this is the same point, a very similar point with guarantees when assigning. And just to build on that as well, the landlords will be agreeable as well because of the benefit of rent reimbursement, as I said. So there's that financial security for the landlord. And of course, we can draft the lease to accommodate this arrangement, make sure that any extra red tape is cut off. Whether there may be a deed of covenant required, this is just to create a direct contractual link with the incoming GP and the landlord. In this document, it will confirm that the incoming GP will comply with the obligations and terms of the lease. Alternatively, if there's a more complicated lease assignment where a set of GPs are trying to take on space from another outgoing tenant, such as a trust, pharmacy, or other GP practice, there are several practical considerations to take into account, and that's on both sides as well. So before I get into any pitfalls of an assignment, I would say that a surrender of the lease should be considered first. So instead of taking on a lease which has been going for, say, 10 or 15 years, consider the parties would be willing to surrender it first, as this will likely put the incoming tenant in a more favourable position. And then you get to take on a fresh lease with modernised terms and no inherent or pre-existing liabilities. And it's these pre-existing liabilities that require a lot of inquiries to be made before an assignment takes place. So in terms of the main concerns of taking this on, first of all, the DV should be on board and agree in principle to the assignment. An official letter with rent or recommended terms can follow on later, but it's best that you just keep them in the loop at the start. Secondly, service charge and rent. Best to check the service charge accounts or the budgets as they're referred to for the last 3 years, just to see what is and what isn't included in the landlord services. So yeah, ensure that your legal advisor makes the appropriate inquiries as mentioned with the outgoing tenant and the landlord to be. So there may be rent arrears, or there could be outstanding rent reviews as mentioned before that need to be addressed, or there may be large works that need to be carried out over the next couple of years, which will then be fed into the service charge. So if you're taking on an older building, for example, with a lift which hasn't been maintained properly or a roof that needs replacing, you need to be careful if you're taking on that lease that you're not going to be left with a hefty invoice to pay for any of these repairs or replacements. So as I mentioned before, you'll inherit all existing and pre-existing liabilities and be responsible for anything that's come before unless you address this in the assignment documentation or via a commercial negotiation with the other side. So yeah, dilapidations kind of links into that. This is a schedule that the landlord commissions towards the end of the term, which lists off the repairs and alterations that they've priced up with a builder or surveyor. And these repairs will be based off the usage by the tenants that have occupied the lease previously. So yeah, even if the lease has been assigned a couple of times and it lands with you on expiry, the full cost of these dilapidations will rest with you. Now, there are certain situations where this might not be the case, so the landlord may choose to serve an interim schedule of dilapidations on the outgoing tenant. So the owner of the lease is passing it on to you, which would be ideal, but it is best to get a specialist surveyor in who can highlight the repairs expected, make sure that they're charged to the tenant. And with the surveyor's opinion, it's useful to confirm what repairs are also the responsibility of the landlord and which falls with the tenant. Some repairs may be with the landlord but charged back to you via a service charge. So you would still be kind of given an invoice, but maybe in a proportioned way. So it's just as important to get a surveyor for that opinion too. And when you have this surveyor's opinion, it'll give you an opportunity to discuss liability for the repairs with the outgoing tenant, if there's an assignment going on, or the landlord if a new lease has been entered into after a surrender. And it may be possible to perhaps limit your liability by either agreeing a payment from the outgoing tenant towards the liability, or agree that the outgoing tenant will carry out the repairs before you take on the assignment. You also have the choice to agree a schedule of condition. So this would be like a photographic schedule of the whole property, all different rooms and areas that will be appended to the lease or to the lease assignment to say this is the state that the new incoming tenant, us as GPs, are taking on the property, and we will not repair it into any better state of repair or condition than as you see it today. Okay, so that's assignment in a nutshell. I'm just going to move on to the next slide and the next topic within alienation, which is sharing occupation. So whilst some landlords may otherwise be reluctant to allow for their tenants to share occupation at the property, as it's usually an undocumented arrangement, we do know that the NHS encourages use of primary care premises to be maximised so far as possible. So the lease should incorporate an ability for the tenant, for you as GPs, to share occupation with other healthcare providers or occupiers providing similar services. Now, there are certain conditions to this. You can't charge a rent when sharing under this particular clause, and you will not be able to grant exclusive occupation, so for example, handing over the keys to them for unlimited use. It's also a standard provision that no relationship of landlord and tenant is created. So in handing over the keys, you might inadvertently create such a relationship and breach the terms of the lease. Of course, if you've got any other questions on that, or you have a similar issue, then yeah, please don't hesitate to get in touch. Now, moving on to the last point within alienation, and the next slide is underletting. Just to quickly touch on this, an underlease is essentially a lease granted out of a lease, as opposed to the lease being granted by a freehold landowner or a tenant. as you'll see on the slide, you get the situation of a superior landlord who is the landlord to the tenant, and then the tenant who is actually a landlord themselves to an under tenant. So you kind of get these two different leases in play. Now, once an underlease has been granted, or you've got a lease which contains a provision which allows an underlease to be granted, there are various conditions attached to this. The main one being that you can't charge a rent or premium above what you're already paying for your own landlord. Now, that would be the situation if you were granting an underlease out of your lease. And if you are taking the lease, they are not allowed to charge you a rent or premium which is more than their current lease. Now, the underlease will usually have to prohibit further underleases, so there isn't an endless cycle of leases being granted with references back to a superior lease or head lease. And then it's also important to note that you cannot expect a rent reimbursement while still receiving a rent for an underlease. So there'll be a proportional decrease again, which should first be approved by the DV. So yeah, just to summarise, as you can see, there are a number of complicating factors when looking at alienation or dealing with your lease. And the best course of action is to always consult us and the district valuer well in advance of agreeing and entering into such arrangements. So that includes the main part of the webinar, and I'll pass back to Jess. Thank you very much.
Okay. This sounds like it refers to what I was discussing earlier about this double income principle. So I think I'm not sure who's asked the question, but I think the point is that they've got let's say a third party occupying a room within the premises, and they're charging an income, or they're charging money for them to occupy that space. I suppose the question is, it's a matter of is it genuinely a rent? If it is, then that obviously goes against the principle that I was talking about before. But if it is simply a sum that is being used as a contribution towards the non-reimbursable costs, like the service charges or reception or things of that nature, then that's fine. I would just say it's worth documenting that clearly and properly, and perhaps not calling it a rent in that document. It's not, because you're not suggesting that it's an income that relates to the floor space occupied in terms of a rental. It's simply a contribution for other costs. But yeah, I think it's a matter of, provided that's the case, I think it's just a matter of getting that documented clearly in terms of what it actually is. Yeah, on the first point, the rent review provisions would usually say that time is not of the essence. So that's the point Harry was making, i.e. a landlord can retrospectively trigger a valuation that they haven't triggered on the valuation date itself. So that's the usual provision you will see in the lease, that time is not of the essence. So if that provision is removed and there's nothing there, then at least arguably it does make time of the essence, and it therefore perhaps limits the landlord's ability to trigger a rent review beyond, or too far beyond, the rent review date. I don't know off the top of my head of any case law that's dealt with that particular point, but if you want us to look into that further, I'd be happy to. Just drop me an email. I see. Okay. So I think this is describing a situation where the landlord has started to charge VAT during the lease term, because if the landlord was going to charge VAT from the start, that would hopefully have been clear, and then that would have hopefully have been approved as part of the lease approval process at the outset, i.e. the rent plus VAT, all of which would be reimbursed. If it's the case that the landlord has subsequently, after the commencement of the lease, decided to charge VAT, then it is possible to obviously get that reimbursed. That's there's nothing preventing you from doing that. But I think you would be best placed to write to the ICB and request and inform them of the change and request that VAT element is reimbursed on top. Because you are entitled to recover that under the premise cost directions, provided it's requested. So it really, I'm not sure from the question whether it's happened at the start or during the lease, but hopefully that answers the question. Okay, so yes, it's still very much valuable and recommended to get a lease in place as soon as possible if you don't have one. Can it be done retrospectively? In a sense, yes. In that the lease itself will be dated on the date that it's completed, but the term commencement date can be backdated to reflect the date of occupation of the tenant. So there is a retrospective element there. In terms of risk to be aware of, I suppose, well, I think that the larger risk really is not having the lease in place, because the longer you don't have that in place, the more uncertainty there is. So I don't think there's any particular risk of, getting the lease in place, because at the end of the day, it's going to provide certainty between the parties in terms of who's responsible for what. I suppose you could say that the process of trying to get a lease in place retrospectively can lead to negotiations about what is actually agreed and what are the terms of this occupation, which itself can obviously lead to issues if there have been misunderstandings about the basis of your occupation. So I would just tread cautiously if there are any potential misunderstandings between landlord and tenant in terms of what the basis for the occupation is. And in your case, I would suggest seeking legal advice before approaching the landlord, just so that you can understand what your current legal position is in the event that for one reason or another, you actually can't come to an agreement on terms for a new lease with the landlord. You want to be sure what your position is, I think, first, before you sort of open that can of worms, as it were. Yes. In short, yes. The review dates are dictated by the lease itself. Again, it goes back to that point about the first stage of a rent review always takes place, what is expected now to take place under the 2024 directions, between the landlord and the tenant first. So in terms of the rent review, it's whatever the lease says is the rent review date, that is the date to follow. Again, the sort of district valuer's involvement is as a second stage. So yes, it's the lease that dictates the review dates. Not necessarily. It does happen sometimes. It all depends on the negotiation for the lease renewal. If you're in a position where the landlord is saying, if you're in a weaker position where you don't have any rights to occupy beyond your existing lease expiry date, and the landlord is insisting on you covering their costs as part of the new terms as part of the deal for the new lease, then you can be in a difficult position to argue against it, I suppose. But it's by no means a standard position. It's just a case of the negotiating strength of the parties. As with any lease renewal, I would just again recommend that you seek valuation advice and advice from a solicitor as well.